Here I have got a ZANU PF responding affidavit to the Constitutional Court challenge addressed to Ibhechu Ligazulu, as well as also the leader of Ibhechu Ligazulu, that is Mbuso Fuzwayo. I think as you actually notice this, I will send a link also on Tronpani Global News TV, that is Facebook page, to give a clarity on the matter. From the look of things, Mnangagwa, the cunning Mnangagwa faction looks forward to actually pursue the 2030 term extension. In this regard, Mnyarazi Machacha makes it actually quite plainly that ZANU PF intends to mutilate the constitution. Where is Zimbabwe going? This and more would be ventilated on this live broadcast. Greetings and welcome to the channel, the Tronpani Global News. If you're watching us for the very first time, please do remember to press the red or black subscribe button so that next time when we beam live, you become the very first one to watch us. So the papers are filed as follows in the Constitutional Court of Zimbabwe, and the case number is CCZ-46/25, held at Harare, and it is stamped, which means it has been accepted in the matter between Mbuso Fuzwayo, first applicant, second applicant Ibhechu Ligazulu, and they have actually cited these following, that is further cited these following: Zimbabwe African National Union Patriotic Front, that is ZANU PF, first respondent, Minister of Justice, Legal and Parliamentary Affairs, that being the second respondent, and then the Speaker of Parliament, third respondent, Attorney General, fourth respondent, President of Zimbabwe, fifth respondent. So you would know that this is a bogus Constitutional Court application. They have planned it, pre-planned it, and this is the case that would be used to actually, the judgment on this matter would be a green light to Emerson Tambutso Mnangagwa faction, extending his term of office up to 2030. In fact, it could be even more. Let me see what is written here. First respondent, notice of opposition. Take note that first respondent is opposed to the court application order sought in the above matter. Take further notice that the affidavit and documents attached shall be used as the basis of the opposition. Take further notice that the application served on 13 November 2025. So ZANU PF has been busy from the look of things, whilst people are still taking this matter for granted. Take further notice that unless an intention to contest such indulgence is earlier indicated by applicants, first respondent shall orally seek upliftment of bar at the hearing of the matter on the basis of amendments contained in the affidavit attached. Take further notice that first respondent's address of service is care of is in the care of the legal practitioners specified below, stated at Harare this 2nd December 2025. So I don't think this is important. The matter that is, and also they did not respond to, ZANU PF did not respond to Mbuso Fuzwayo and Ibhechu Ligazulu alone. They further also responded to Mnyarazi. They also, getting mixed up. In fact, they responded to Ibhechu Ligazulu. Now let me read first respondent's opposing affidavit. It will be quite a longer discussion. I'll be reading and where possible actually try to explain. In the undersigned, Munyaradzi Muchacha is the one on behalf of ZANU PF making this application. Hereby make an oath and state that I am a person of majority status and first respondents National Political Commissar. I know the facts and can positively swear to them. I tell truth, the whole truth, and nothing but the truth. I have authority to depose to this affidavit on behalf of first respondent as set out in the resolution annexed marked A. The first respondent, by the way, is ZANU PF. I have read and understood the application and its annexed. I point out that relief sought is opposed. So this would be some sort of bogus opposing of the relief sought by Mbuso Fuzwayo. It says upliftment of bar. I shall move for upliftment of bar through an oral application to be advanced by counsel at the hearing of the matter. The nature of my duties is such that I am mostly up and about the country, attending to party affairs. In the period leading up to the date thereof, I was under pressure to attend to urgent party business out of the capital. I did not have adequate time to conference with counsel to provide instructions when papers were drawn to discuss the drafts until their perfection. Given that the matter is of national public interest, a position on which the application is also pitched, I asked whether court may be pleased to condone the delay or allow my papers to be considered in the determination of the matter. Now, preliminary objections. I commence, however, by making procedural objections to the application which are dispositive of the matter. These are that the notice of motion is fatally defective in that it does not set out the matters required to be set out by Rule 26(3)(a) to C of the Constitutional Court Rules 2025. In terms of that rule, it is the court application itself which must be set out. The grounds on which it is contended that it is in the interest of justice for direct access to be given, the nature of the relief sought and the grounds upon which such relief is based, and whether the matter can be heard absent the leading of viva voice evidence. The application is not compliant with Rule 22(2) and consequently fatally defective because the rule is peremptory. I move that it be sunk off the roll. So the first application that Munyaradzi Muchacha through ZANU PF is making is to actually ask the court to dismiss the matter on technical grounds that it does not qualify to be parachuted to the Constitutional Court without passing other lower courts. So that is what he would be advancing. And then the second, the application is incompetent in that the founding affidavit, contrary to the peremptory provisions of Rule 22(8)(a), does not plead prospects of success of the substantive application. The entire affidavit is cast obviously to this requirement. Contrary to the peremptory provisions of Rule 22(8)(c), does not engage the requirement of whether the matter can be disposed of absent viva voce evidence and incompetently cite law and case law authorities, including the court's dicta, as if it were a set of heads of arguments. It says, matter is not ripe in that the cause of action is a complaint against a desire that has not manifested itself into an amendment of the Constitution. So here he is using the argument that has been advanced by the Speaker of Parliament, also being a ZANU PF member, and also the Secretary General, that is Advocate Mutenda. Until there is such amendment, the complaint advanced by applicants is abstract, as there is no telling that the amendment will or will not say or how it will be worded. The court ought to refuse the invitation to speculate. 5. I submit that on account of these obvious infractions, the matter ought to be struck off the roll. The context, that's here. I concede that the matter raises issues that presently are at the fore of the nation's mind and concerns. It is therefore an important matter, and consequently there is need for me to put matters into their proper context. First respondent indeed intends to amend the Constitution of Zimbabwe. So ZANU PF is coming out openly now that it intends to amend the Constitution of Zimbabwe with a view to implement Resolution 1 of 2024. This is an intention, but nothing concrete is yet in place. So he says it's an intention, nothing concrete is yet in place. I think it's just playing with the minds of people of Zimbabwe. This intention is constitutional because so now they're arguing that changing the constitution would be constitutional because the Constitution of Zimbabwe says it can be amended. No democratic constitution worldwide immunizes itself from its amendment. All constitutions are amendable. I give the example of Article 5 of the Constitution of the United States of America and Section 74 of the Constitution of the Republic of South Africa, which both embed mechanisms for their amendment, affirming that all provisions from rights to structures are amendable, provided the prescribed procedure is followed. The Constitution of Zimbabwe in Section 328, I think now they are advancing the points of Professor Jonathan Moyo, as read with Section 131, mandates a clear, rigorous, and non-political gauntlet, a 90-day gazette notice, public hearings and submissions, and 2/3 affirmative votes in each House of Parliament at final reading, culminating in presidential assent. This is a parliamentary and technical odyssey, not a partisan skirmish in the political gutter. The imperative is to adhere strictly to prescribed amendment process and procedures. The issue, therefore, should not be that there is a desire to amend, but rather whether the desired amendment would be done in accordance with the process and procedure prescribed by the Constitution of Zimbabwe itself. I state for the record that the first respondent is a law-abiding organization. It is the party that ushered in the same law which applicants say first respondents wants to violate. That cannot be true. Any desire to amend the Constitution of Zimbabwe shall be done in accordance with its terms and processes. I must point out that Section 32A of the Constitution of Zimbabwe entrenches multi-party democratic political system as one of the several principles of good governance which bind the state and all institutions and agencies at every level Within this system, a governing party with the necessary legislative majority is well within its right to seek the amendment of the Constitution in the prescribed manner. It is therefore puzzling that applicants simply declare that an amendment of Section 95(2)(b) of the Constitution of Zimbabwe would require a national referendum without grounding that declaration under subsection 1 and 7 of Section 328. It must be mentioned that first respondent did not pass Resolution 1 of 2024 for the fun of it, or obviously to the realities faced by our people. The resolution is grounded in the reality that many African states, including Zimbabwe, have been crippled by toxic barriers so is bringing the breaking barriers to socio-economic progress. Shorter 4 to 5 year terms of office have trapped governments in dysfunctional, perpetual election modes. They prioritize toxic populism over service delivery and fueling the scourge of disputed polls, policy paralysis, corruption, inefficiency, and societal polarization. The Breaking Barriers initiative, it is coming now if you have read it. These cycles typically elevate survival above long-term reforms, eroding public trust and fragile institutions and polarized political environments. Against this backdrop, there are now growing calls across Africa advocating stabilizing shifts to 7-year presidential and parliamentary terms of office for breathing space to combat electoral fatigue and enable governance focused on service delivery and infrastructural development to tackle endemic hunger, poverty, disease, and ignorance. This is the party that has been the governing party for more than 40 years. Now it says it needs 7 years. All for what? What the hell? Now, let me go forward. First respondent Resolution 1 of 2024 reaffirmed and prioritized in October 2025 to enable Comrade Emmerson Tambutso Mnangagwa to remain in office until 2030 signals this broader continental shift to 7-year terms of office for current and future leaders and legislators, dismantling barriers of uninterrupted progress. It is my view that for our dear Zimbabwe, adopting this change at this juncture would strategically break the toxic cycle of disputed elections, empower consensus-driven governance, and advance the attainment of an upper middle income future by 2030. So they want, in this regard, they want the courts to be prophets. Who actually knows if ZANU PF has failed to achieve an upper middle income state for the past more than 40 years? What guarantee will the courts have that if just 2 years added, this would be achieved? I think people are taken for a ride. I point out that Resolution 1 of 2024 is achievable without amending Section 328. Now, you see, it's the Breaking Barriers Initiative or holding a national referendum. That is because the constitutional reforms desired by the resolution seek to amend term length provisions, single term definitions in Section 95(2)(b) and 1431 in accordance with Section 3285. They do not mean to amend the term limit in Section 912, which is governed by Section 328 and has 3287 and has national referendum implications. So, in this regard, it is quite clear what Mbuso Fuzwayo and others did. They did not invite ZANU PF to actually bring this issue, but they have strategically brought this issue so that the Constitutional Court gets to make a pronunciation on this. Remember, this Constitutional Court is not a fake, it is a captured court. Definitely the judgment has been prepared already before the sitting. I can attest to you, that's how it works in Zimbabwe. The judgment has already been prepared. So now they are bringing these issues contained in the Breaking Barriers initiative so that the Constitutional Court of this captured guy who does not even deserve to be a Chief Justice will have to pronounce on paragraph 14 of their responding affidavit. And because it is ZANU PF, the Constitutional Court would not say, but the initial affidavit did not actually derive us to this direction. So they are deriving now the court to their direction so that it answers to this. You know, this is madness that ZANU PF is advancing. They claim that globally countries now wants to extend term of office to 7 years because 4 to 5 years is small. There is absolutely nothing like that. This is lies. This is fiction that is advanced by ZANU PF. It is not a global agenda for the terms of office to be increased. I've never heard anywhere in Africa. Maybe this is what is discussed in secret corridors of detectors. Not Africa. They should not actually taint or dent Africa. They should actually say the enemies of progress on the African continent. That is the so-called revolutionary political parties. They are the ones who are actually advancing, in fact, not extension of term to 7 years, but who are advancing a nefarious agenda to create dynasties. This is where Emmerson Tambutso Mnangagwa is going. Now, let me just continue reading. First applicant's affidavit. I turn to the substantive allegations. I take no issue with these formal affirmance, save to restate points in the preceding paragraph. It says 80 paragraph 9 to 10. The nature and intent of the application are noted. I restate, however, that the matter is afflicted by the infractions pointed out above and cannot go past. I point out as well that an amendment of the Constitution of Zimbabwe is, in accordance with its provisions and procedures, cannot constitute a violation of rights specified in the same Constitution. I am aware that provisions found in the same Constitution must be read so as to create harmony with the same document. It is impossible with that approach in mind for an argument to be made that compliance with the Constitution in amending it would be simultaneously constitute an infringement of rights specified in the same Constitution. 19. I also submit that amendments by nature mean that the original position of the law will no longer apply going forward. This is neither discriminatory nor a denial of the rights alleged by applicants. Everyone in the country would be subject to the same law as amended, and all rights will be enjoyed in conformity with the law as amended. This is the essence of amendments. No cause for complaint may arise from them save for the issue of whether the amendment submits itself to the procedure set out in the Constitution. 20. As I have placed on record Resolution 1 of 2024, it is predicted on the reality which is in the public domain that Comrade Dr. E.T. Mnangagwa is a staunch constitutionalist. The party that he presides over can only be a constitutionalist also. Consequently, the amendments will be in accordance with the strict requirements of the Constitution of Zimbabwe. You see the concept that I have been saying, I have been at pains for a long period of time trying to interpret what Mnangagwa means when he says he is a constitutionalist. Here they have clarified what exactly he means. It doesn't mean that he's not interested in becoming the life president. No. It's a statement that was coined, long planned, long time ago to deceive the people of Zimbabwe. A lot of media personnel were thinking that, no, but Mnangagwa is saying no. No, he will come out and say this is not the proper interpretation of what I meant. If you are to actually listen to paragraph 20 that has been filed by ZANU PF. Now let me read very fast. I wish to conclude this very fast. This is true, whilst it is the mandate of the Secretary for Legal Affairs, who is also the Minister of Justice, Legal and Parliamentary Affairs, to come up with the package of constitutional amendments as would give effect to the resolution. I'm aware that he is presently working on drafts aimed at achieving this. You see, they are saying he is working on drafts aimed at achieving the 2030 term extension. ZANU PF is now coming out openly saying, so what? Okay, I can place it on record that the draft amendments would be publicized through the government gazette soon. It will become clear from that publication whether the amendment triggers section 3287 or not. At present, applicants do not know this, and it is not in the interest of justice for the court to pass judgments on issues that are speculative. But he is giving evidence. If it was a normal court, they were going to actually hold accountable this Munyaradzi Machacha, because in paragraph 21, he is actually arming the citizens of Zimbabwe. He has actually placed it on record. It is now a fact that ZANU PF intends to extend its term of office up to 2030. He has actually publicized that they are drafts that are being done by the Minister of Legal Parliamentary Affairs, that is Ziyambi. He has actually made it quite clear. Now, let me read. I object to the tendency of applicants to plead the law in their founding affidavit. It is improper because if I were tempted to return the favor, these will cease to be affidavits through which to place facts before the court. Additionally, there would be nothing left to do in heads of arguments. Be that as it may, it is admitted that the reform package which is being implemented as directed by first respondent inter alia amends section 95(2)(b) and 1431 of the Constitution of Zimbabwe. Their amendment, however, specifically is the manner contemplated by Resolution 1 of 2024, and the drafts which I am privy to does not trigger section 328(7) and the requirements for a referendum. So ZANU PF is now coming out so very openly. 24. I point out that neither section 95(2)(b) nor section 1431 are term limit provisions under subsection 1 and 7 of section 328. These two provisions are rather amendable under section 3285, as will be urged by counsel at the appropriate stage. This interpretation is firmly grounded in the ratio of the judgments which applicants build their case on. In that matter, this court took time to distinguish between fixed, rigid term limits and contingent provisions that allowed for variability in actual tenure. Now, let me continue reading this nonsense. Ideally, these averments, the apprehension is based on speculation and non-existent risk. Even then, it is based on misconstrued and flawed understanding of the constitutional provisions implicated by the resolution. I'm aware that this court has, in the same judgment, relied on by applicants taken position which aligns with the premise and object of the resolution, namely that amendments that extend variable contingent provisions such as age limit do not violate section 3287. Because they do not extend a fixed length of time, I submit that this applies squarely to section 95 2b and 143.1, which are similarly event dependent and therefore amendable without referendum. Now, I concede that applicants have the requisite standing to advance their complaints. I, however, take issue with the recital of case authorities in affidavit. Additionally, the apprehension on which applicants establish their standing is wild and awkward because it is based on a flawed understanding of the law, particularly the distinction between fixed term limits, such as section 9(1)(2), and contingent term lengths, such as section 952b of the Constitution of Zimbabwe, an issue which this court has already spoken. Now, I consider that the matter is of general public importance and that the public interest is aroused by it. I tell, however, that applicants have made a case for a relief that they crave. I also issue with the citation of case law authorities and advancing of legal arguments as if the affidavit was a set of heads of arguments. 28. I tell these amendments. We are almost at the end. Okay. Right. So let me just read this last part because I promised I will send this link on my Facebook page. I was almost done. I was left to read just a single page. Others are just attachments that this is from ZANU PF, and it says all correspondence to be addressed to Secretary General 2 December 2025, annexed to a resolution authorization to represent the party in the Constitutional Court application number CCZ 46 in the matter between Mbuso Fuzwayo, first applicant, Pechuliga Zulu, second applicant, and Zimbabwe African Union Patriotic Front. It's an authorization. The other was left to read a page. I don't think there is absolutely nothing important to read because I still have got a lot of issues to dissect. I was simply reading for you what is contained. So I'm quickly sending a link to our Facebook page for those who want to read for themselves. Thank you very much for watching us. If you are watching us for the very first time, please do remember to press the red or black subscribe button so that next time when we beam live, you become the very first one to watch us. Umhlabane is signing off. Let me love and leave you. Let's meet on the other side of the live broadcast as I ventilate the issue more.